All right. Well, I'll consider ourselves a critical mass for the time being so that we can get started. And as we're just flagging in the chat now, a recording of this webinar and the slides themselves will be available after. So if you missed the intros at the beginning and want to come back and learn more about Vicente and Sahar, you can always catch the webinar. But with that, we'll dive into it. So Sahar and I are both partners at Vicente LLP. The firm was formed over 10 years ago, and it's the first and largest cannabis and psychedelics law firm in the country. So we have a lot of experience representing entrepreneurs in this industry. It's like there's an audio issue. I'm not quite sure how to address that.
Let me see is my audio also garbled a little bit? Okay. So Vicente LLP is one of, if not the largest cannabis and psychedelic law firms in the country. For well over a decade, we've now helped clients navigate the field in really highly regulated industries, grow their businesses, and really advanced hemp, cannabis, and now psychedelic policy. We've really grown to be a national presence around the country, spanning California, Colorado, Florida, Missouri, Minnesota, New York, New Jersey, Texas, and really also have either boots on the ground relationship or expertise in just about every other state where there is some version of a regulated cannabis industry, be it medical or adult use. Our services really span all of the needs of the cannabis industry, including federal, state, local licensing in some of the most difficult to obtain states and localities, corporate and transactional services, regulatory compliance, economic analysis, policy research, drafting, advocacy, real estate, government relations. So really just about everything that a highly regulated industry would need to be able to succeed and move forward. Next slide, please. So the panelists are, of course, myself and my partner, Meg Nash. I'll give a little bit of background about myself, and then Meg will hop on and give a little bit of background about herself. I'm Sahar. I'm one of the partners at Vicente LLP. I'm based out of Los Angeles. My expertise really includes corporate transactions as well as banking. So really everything having to do with forming your entity, growing your entity, mergers and acquisitions, financing, lending, licensing, just about everything that requires an agreement. And I also work, I chair the banking group here. So really addressing the continuing need to access depository accounts, depository institutions, and figuring out how to work within the banking system. Next slide, please. So that's Meg's background, and that's, of course, my background. Next slide. Okay, so the beginning of this presentation will cover some of what we've covered in the past. We really wanted to also put it here so that those who weren't able to participate in the last presentation could get a solid baseline of what's been happening in Maryland that's been leading up to the updates we're going to be providing in the latter half here, and to also provide a baseline for those who have been following to give them a full view of what's been going on. Next slide, please. So a timeline of what we've been seeing happening in Maryland is, of course, at the end of last year in November. Oh, Meg, looks like you're back. We'll continue to give Meg a moment. So what's been happening thus far is that at the end of last year in November, Maryland voters voted to allow for adult use to come through with question 4 on ballot. Meg, is that you? Seems you're still a little bit garbled. So thereafter, in April of this year, the Maryland General Assembly passed the Cannabis Reform Act, which allows for cannabis sales for to adults 21 and over. And it also includes the conversion of existing medical cannabis business licenses, because keep in mind, even prior to the passage of question 4 in November of last year, Maryland did still have, of course, a medical program. In May of this year, we saw the governor signing the Cannabis Reform Act into law, which has really created the adult use framework for cannabis in Maryland, which is what we're all going to be working off of as far as licensing and conversion go. Last month in June, the Maryland Cannabis Administration hosted the Maryland Cannabis Conference, which provided key information on provisions of the Reform Act and also detailed what would be coming up as far as licensing opportunities. Next slide, please. So continuing forward, later last month, the MCA hosted a Q&A webinar that provided information on the, first and foremost, conversion of the medical licenses, compliance guidance, and other operational considerations in advance of the launch date of adult use sales, which took place at the beginning of this month. At the end of last month, we saw the emergency regulations be approved, and they became effective at the beginning of this month and will remain in effect until June, the end of June, should be next year. So July 1st, we saw the launch of adult use sales. They were quite successful, exceeding 21 million during just the first week alone. In the last week, the MCA hosted its first technical assistance seminar at the University of Maryland, Eastern Shore. And just a couple of days ago, Governor Moore appointed Audrey Johnson as the acting director of the Office of Social Equity and Courtney Davis as deputy director, and also appointed members of the Cannabis Public Health Advisory Council. So here is really what we know so far, and how the adult use regulations are expected to have an impact on licensing. So the first round of licensing is expected to, will be taking place September of this year. And the number of licenses in each category, being of course standard, micro, and incubator, have already been set. So as far as standard licenses go, we're expecting to see 20 grower licenses, 40 processor licenses, 80 dispensaries. For micro licenses, it's 30, 30, 10. And for incubator licenses, we're expecting, or we will be seeing, I should say, 10. The new license, next slide. The new license categories that are available, of course, are standard, micro, incubator, and on-site consumption. Standard will authorize growers to have between 10,000 and 300,000 square feet of canopy, indoor canopy, and processors to process more than 1,000 pounds of cannabis every year. Dispensaries under the standard licenses will be permitted to operate a store at a physical location that sells cannabis and cannabis products. Micro licenses, of course, are smaller, allowing growers to have no more than 10,000 square feet of canopy space, and processors to process no more than 1,000 pounds of canopy every year. Dispensaries will be permitted to operate delivery services without a physical storefront. provided, of course, that the licensee does not have more than 10 employees employed. Incubator licenses will authorize the licensee to operate a facility within which a micro licensee may operate, so that the micro licensee and the incubator licensee are kind of part and parcel with each other. And then, of course, there is the on-site consumption license, which will allow a holder to operate a facility where individuals can partake in cannabis activities, so smoking, vaping, and consumption, which of course have to happen outdoors. Next slide, please. So the first round of licensing, which will be taking place in September of this year, is of course open only to social equity applicants, which have been defined as an applicant that has at least 65% ownership and control by one or more individuals who have lived in a disproportionately impacted area for at least 5 of the last 10 years, attended a public school in a disproportionately impacted area, or for at least 2 years attended a 4-year institution of higher education in Maryland, where at least 40% of the individuals are DIA, or any other criteria that are established by the administration. A disproportionately impacted area is, of course, defined as a geographic area identifiable by the Office of Social Equity that has had above 150% of the state's 10-year average for cannabis possession charges. So the DIA is, of course, based on long-standing data that's being analyzed by the Office of Social Equity. Next slide, please.
Hey there, I don't know if you can hear me any better now.
Oh, we can. Thank you, Meg. I will hand it over to Meg.
Wonderful. Thank you, Sahar. I will just stay off video in case that was, involving too much bandwidth for the time being. So as mentioned, this upcoming licensing round is fundamentally going to include an application fee, an application that will be developed by the Maryland Cannabis Administration that's going to include an operational plan, business plan, diversity plan, as well as evidence demonstrating that you qualify as a social equity applicant. Is it the same? Okay, thank you. You can only submit a total of 2 applications, and they can't be for the same license. So, for example, you can apply for a retail license and a micro retailer license, but you can't apply for 2 retail licenses. Let me see if I can try to call in.
I'll take the next slide. Okay, so as far as the application process and the issue of licenses will go, there are, of course, limits. So an applicant, which is really any individual. Oh, did you want us to go through the last slide again if it was garbled? Okay, let's go back to the last slide. Okay, so the first round of licensing that's taking place in September will include, of course, an application fee and an application that's been developed by the administration. And really the keystones of the application will be an operational plan and a business plan and a detailed diversity plan. And then, of course, the evidence that the applicant qualifies as a social equity applicant. There are application limitations for this first round of, oh, Matt, you have a little bit of echo going on. There are, of course, limitations for the application round in September. Applicants can only submit a total of 2 applications, and applicants cannot submit 2 applications for the same license type.
Let's try this again.
Oh, great. You sound less garbled.
Okay, great news. iPhone for the win.
Yes.
There it looks like there's a request for elaboration on the last 2 points if you want to finish up, Sahar.
I was going to say you can take it, Meg.
I'm just not quite sure where we were because I just hopped in.
Oh, we're talking about the application limitations as far as one applicant being able to only put in a total of 2 applications and applicants not being permitted to submit 2 applications for the same license type. So I think examples are being requested of how exactly that works.
Okay, perfect. So if you wouldn't mind going to the next slide. Essentially, what this is going to look like is that if you, John Doe, form entity ABC LLC, and you're a social equity applicant, you can submit an application for one retail and one micro retail, or a retail and a grow, or a retail and a process, just as long as it's not the exact same license. But then if you, John Doe, want to form another company, applicant XYZ LLC, with a friend of yours who's also a social equity applicant, you cannot then submit additional applications. And the reason why, this is considered and included in the regulations is because the applications will be awarded via lottery. So obviously, to the extent that there's more applications submitted on your behalf, the increased odds are. So this is really a policy decision to level the playing field in terms of the number of applications that will be submitted in order to kind of honor the lottery process. So moving on to kind of the process and issuance of license. And as I've indicated in these slides, the COMAR 14170502, this guidance is derived from the regulations that are now in effect and that were released June 23rd. So to the extent that, anyone's interested in additional information there, that's kind of the regulatory source. I think one benefit of this licensing round is that the MCA cannot require you to possess or own property at the time of the application. So essentially, anyone seeking to apply for a license in this upcoming round does not need to have a location selected, a lease, a letter of intent, a deed, anything like that in order to apply. That said, the MCA is going to offer an opportunity to verify applicants' social equity status prior to the initial application and licensure, but it's not quite clear how this will be implemented yet. There's been some mention of a specific verification portal that we expect to see in August, and we'll touch upon that a little bit later. What we're currently waiting for now is the formal announcement of the application round, which is required to come at least 60 days prior to the acceptance of applications. Given the timelines that have been spoken about by the MCA, we were cautiously optimistic that we would see application forms in July or August. That may be a little bit later, just based on kind of the recent appointments to the Office of Social Equity and likely the kind of back-end administrative things that will need to get sorted to get the office set up. But again, it should be within the next few months because they're under this mandate to release licenses before January 1st of 2024. The submission period will last for 30 days. So, to the extent that the submission begins October 1st, you'll have 30 days to submit. There's not going to be like a 5 p.m. deadline on one day where you have to have everything in. So I think that will help in the kind of rolling submission process. The regulations also require the MCA to conduct extensive outreach to small minority and women businesses. And this has already started with technical assistance seminars that have been hosted around the state, as well as other events, kind of more county fairs or other events where MCA will have a presence to provide information. So we expect that to continue in the coming months. And that information is available on MCA's website and is also linked here. So you should be able to access it upon receipt of the slides. Once the application period closes, there will be a release of information about how many people applied. So it should give a little bit more insight as to how the lottery will be conducted and potential odds there. So once the application gets in, the MCA will begin the process of determining whether it meets the minimum qualifications for the lottery on a pass-fail basis. And again, this is going to focus on looking at the operations plan, the business plan, and the diversity plan, as well as verification that the entity applicant qualifies as a social equity applicant. So that's sort of the 4 prongs that we know about right now. Importantly, the regulations indicate that the MCA may request additional information from any applicant after review, and that the applicant will have 10 calendar days to supply it. So this is essentially a built-in cure period. And I think, again, reflects MCA's policy stance that they want to try to make this an inclusive licensing round, and we'll give you an opportunity to kind of supplement or respond to questions in this 10-day period after the application is submitted to hopefully satisfy those minimum qualifications and move on toward the lottery. So as long as that minimum qualifications threshold is met, then you will be entered into the lottery and notified that you are selected. And then after the lottery is conducted, the lottery winners will receive a conditional license, and then there will be a supplemental application. So it's really going to be kind of phase 1 and phase 2 of the licensing process. The conditional license requirements are essentially when you need to kind of throw open everything about yourself and make a ton of disclosures to the MCA, including, criminal history, financial background, verification of any documentation that's been submitted, any prior administrative actions or litigation, as well as offering information or kind of waiving any right to privacy with respect to government agencies, particularly if you've submitted applications for cannabis businesses in the past, and releasing financial institutions from providing information from the MCA. So, given that the first licensing round is kind of coming up quickly, a lot of the things that you might see kind of in a more merit-based or competitive application are going to be handled on the conditional license application. And at this point, it will include property control that will need to be submitted once the conditional license is selected. So while it's not required now, it will ultimately be required upon receipt of the conditional license. The conditional license period lasts for a period of 18 months. You may be able to obtain a 6-month extension if you can demonstrate kind of good faith progress and due diligence towards working towards the goal of opening whatever the licensed establishment is. But this is going to create a bit of a runway to get up and running. This is where kind of I would say the property component comes into play the most, because it will likely include zoning approval. And while, the 18-month period provides a good runway, it will kind of move quickly in our experience as a firm working with licensed applicants, just in terms of getting things done. So while there's no need to start burning capital on property, it is a good thing to continue to consider with the conditional license portion of the application coming quickly after the first round. One thing I did want to mention, sorry, just on the past slide, you don't necessarily have to go back, but after the license is submitted during the conditional license application, applicants will be able to add owners and investors, as long as it does not disrupt the 65% ownership and control by the social equity applicant. And this is, again, important in terms of kind of immediate planning with respect to capital, and the ability to potentially bring on investors after you win a license, when it may be, more attractive to potential investors to move forward. This is, I would say, a bit of an exception to what we see in other jurisdictions, so wanted to be sure to flag it. An additional exception, or, kind of not the norm in Maryland, is that the MCA will retain your application after you submit it. So what this means is that the second round of licensing is expected to occur after May of 2024. And if you have submitted in the first round and you are not selected in the lottery, you can ask the MCA to hold on to your application so that you can be included in the second round. I think this is an important thing to highlight because I think it emphasizes the importance of submitting early and often, and kind of getting your cards, down on the table sooner rather than later, particularly where it will benefit you in the second licensing round. So what we know about so far about the second round of licensing is essentially that it will begin after May of 2024. We don't have anything kind of more locked down than that. But if the kind of efficiency with which the MCA has been moving through everything so far is any indication, I expect that this will also move quickly. That said, there is a statutory mandate to conduct a disparity study looking at the outcome of the first round of licensing, which will inform what the second round of licensing is going to look for. And essentially, this study is intended to, reflect on essentially the makeup of the entities that won in the first round of licensing, and to the extent needed, perhaps make the second round of licensing limited to social equity applicants as well, so that the industry in Maryland really reflects, the diverse population of Maryland and cures some of the harms caused by the war on drugs and the disproportionate impact of the war on drugs. I would say that's really a North Star of Maryland's program so far. And this is just one more kind of reflection of the fact that, this will be kind of a guiding light in the upcoming licensing processes. So in the second round, we'll see more licenses, notably 120 dispensary licenses, up from 80 in the first round, 70 micro licenses for growers and processors, and then the 10 incubator space licenses and on-site consumption licenses. These numbers obviously matter with respect to kind of the build out of the industry, but also, indicate kind of how many lottery tickets are available. So wanted to be sure that this information was presented to all attending, even as we're looking forward kind of further down the line here. Any third round of licensing is not guaranteed at this point. It will be based on market demand. So given kind of the manner in which the first and second round of licensing play out, including how quickly licensees can get up and running, we may see a third round in the future, but it's not guaranteed. And again, I would just say that kind of speaks to the importance of applying in these initial rounds in order to get into the lottery now, as there may not be kind of a third bite at the apple, if you will. Sahar, do you want to?
Yeah, sorry, I was trying to get unmuted. So, of course, one of the first questions that starts to come up around licensing is whether, how, and in what capacity a license can be transferred, because, of course, licenses hold great value and transference can bring a great amount of value to the holder of a license. So the Maryland rules have specific understandings of what a transfer is, and the MCA actually provided a guidance bulletin on this as well. A transfer, according to Maryland, is 100% ownership interest of a license, or really the equity therein, or the transference of 50% or more of the ownership interest of a license. So really anything from 50% or more up to 100%. And within the definition of transfer is also encapsulated the transfer of less than 50% ownership interest, conveying a controlling ownership interest. So this means that if you have someone who has 40% interest and another person who has a 60% interest, if that person who has a 60% interest moves enough of their ownership over to the minority 40% holder, such that the minority 40% holder now has a majority, that is also considered a transfer. So really think about transfer for the most part as any time that someone who did not previously hold a majority ownership will then hold a majority ownership percentage. So as far as converted licenses go with respect to transfer, businesses that convert a medical cannabis license to a standard medical and adult use license are subject to a 5-year restriction on transferring ownership or control of a license. There are exceptions to this, which really are the disability, incapacity, or death of a licensed owner, bankruptcy, receivership in accordance with a lending agreement, and a court order. It should be noted that unless a lender has been specified by the Maryland regulators as really being a financial institution lender, other non-financial institution lenders or those who are not qualified by the Maryland regulators will not be able to take the kind of security interest in a license that would allow for a transfer in the event of any of these exceptions. So if you are a private lender and you have, provided a loan to a licensee, you've secured the licensee's ownership or the license therein, and some kind of default or one of these exceptions happen, if you are not qualified by the Maryland regulators, these exceptions will not kick in to allow for an override of this 5-year transfer restriction.
Thank you. So having gone over what we know from the statutory authority, what we've seen from the emergency regulations, and what we've gleaned from recent MCA webinars and seminars, there are still a few things that we're waiting for. And those things will impact licensing strategy. So we'll kind of dive into that to kind of probably kind of puzzle over the same things that you all are puzzling over as well. First and foremost is going to be qualifying for and proving social equity status. As we flagged at the outset, Governor Moore recently announced the appointment of Audrey Johnson as the director of the Office of Social Equity and Courtney Davis as the deputy director. This is very important because they will release the DIA map that everyone's been waiting for to kind of check residency requirements and qualifications. So now that it's, at least staffed in this regard, we do anticipate that more information will be forthcoming. With respect to evidentiary requirements in terms of demonstrating that you've lived in a disproportionate impact area or attended public school in a disproportionate impact area, or the, kind of academic institution qualifications, what we know from recent webinars is that they're likely to accept, tax returns showing the address, leases or rental agreements, titles or deeds to the property, voter registration or bank documents. When you get into this, some of the nitty gritty, is it questions that come up, for example, if I have January bank statements for, going back to 2018, can I show every January, or do I need every single month of that year to demonstrate residency for 5 years? That type of thing usually is answered in an FAQ that would come out. Tax returns are typically an easily accessible way to show your address and residency. But again, we don't know just yet exactly what they will be looking for, although these are good kind of guide marks here. Similarly, with respect to the qualification based on public school or higher education, it's likely you will need at least 2 years of transcripts if you're demonstrating qualification based on attendance at a school that had a Pell Grant eligibility population. If it's a public school attendance in a disproportionate impact area, you will need 5 years of transcripts. In my experience, gathering that information typically takes longer than you may think it will. So to the extent that you think that you may qualify, it makes sense to kind of begin some of that outreach now. We do know from the most recent technical assistance seminar, this is on the next slide, that the MCA will engage in a social equity applicant verification process before the application itself is due. This will be, I think, incredibly helpful, both in terms of ensuring that you have the right evidence to qualify so that you're not wasting your time. You can kind of get feedback from MCA early with respect to the social equity qualification process. And it looks like, per the MCA, that there will be a verification portal. So we assume that this will be something accessible either through Maryland One Stop or through a new methodology such that you can upload documents proving both residency or attendance at a public school or attendance at a four-year institution to qualify as a social equity applicant. And likely that you would need to also upload corporate governance documents demonstrating that the 65% ownership and control are vested in the social equity owner. Another thing we know a little bit about, but not enough to totally plan appropriately, is that dispensary and on-site consumption applicants must apply by county, and that each county will have at least one additional dispensary license. These will be based on population and market demand within the specific county, and the lotteries will be conducted on a county by county basis. So again, while you don't need property for the application, it does appear that you will need to make some indication on the application as to where you intend to operate. It can't just be in the state of Maryland and I'll figure it out later. So another good thing to kind of get the wheels turning on. Similarly, for grower, processor, and incubator licenses, you have to apply by region, and the lotteries will be conducted on a regional basis. It is not quite clear what that kind of region delegation will be yet. So another thing we're waiting to learn more about. Finally, with respect to forms and minimum qualifications, these will be released by the MCA. And while we know that you will need an operations plan, a business plan, and a diversity plan, we anticipate that each of those portions of the application will include, a certain set of subheadings seeking specific information about each of these things, whether it's, kind of a pro forma for your business plan, measurable goals for your diversity plan, local partners, kind of your SOPs for your overall operations. This could look differently. So that's kind of one thing that needs to be clarified, because there's a lot of different ways to prepare an operations plan or a business plan or a diversity plan. You want to be sure that you're really applying specifically for this application and specifically responding to what MCA is asking for. So even though there are some lingering questions, there is enough kind of knowledge that can be derived from the legal authority as well as webinars presented by MCA and their proactive outreach efforts to get started now. One of the first things to think about is qualifying as a social equity applicant. Obviously, that is a threshold matter that must be satisfied in order to apply during this first licensing round. So it's important that you're kind of building out a team, whether it's you, whether it's other folks to demonstrate that you qualify as a social equity applicant, kind of gathering that evidence. In addition, it's always helpful to recruit individuals with necessary experience, and that can be cannabis specific or cannabis adjacent, or, you know, another highly regulated industry where, you know, a certain individual's skill set will really demonstrate their ability to contribute to the team. It's clear that, you know, diversity is a key component of the application and of the Maryland Cannabis Administration's goals in implementing the program. And I think that will should be reflected in applicants' teams as well, and kind of future staffing initiatives, including, you know, recruiting efforts in the future. And then, of course, forming the applicant entity that will be submitting the application itself.
So as far as forming the entity goes, of course, the basics are figuring out what exactly your entity will be, which is, will you have an LLC or will you have a corporation at the very basic level? It's important to think about how you want your entity to be governed, as well as how taxation will play into LLC versus corporation. Keep in mind, again, we cannot stress this enough. For round one applicants, ownership must reflect the social equity ownership requirements. So the social equity partner must have 65% ownership and control. And the applicant's governing documents must reflect both the 65% ownership piece as well as the 65% control piece, which we'll get into in the next slide. So currently, the rules, guidelines, regulations that we have specify control as being the decision-making authority over the management, operations, or policies that guide a business, or authority over the operation of the technical aspects of the business. So that is, you know, pretty broad definition of control. It is one of the more broad that we've seen throughout various different states, cannabis regulations. It's really important to note that we actually have examples of what control is. We don't really tend to see this in a lot of other cannabis regulations in other states. But examples of control are, of course, holding a right to veto significant events. So being able to single-handedly say no to, for example, the sale or liquidation of the business, or bringing in a new partner or something like that. The authority or right to make or veto decisions regarding operations and strategic planning, capital allocations, acquisitions, and divestments. So this really does feed into one, which is the ability to say yes or no single-handedly to these major business decisions, the ability to appoint or remove directions, corporate level officers, directors, or their equivalent. So controlling those who run the business, making major marketing, productions, and financial decisions. So deciding how the company puts itself out into the world, as well as how money comes in and goes out of the business, and executing exclusive contracts or significant contracts in the aggregate of $10,000 or greater on behalf of the licensee. So really controlling the relationship that the licensee has with other people. Really, this kind of tends to suggest that both major and more day-to-day decisions will fall under the umbrella of control. And again, remember, 65% control also has to go to the social equity applicant. Next slide, please. Now, this is a little bit of newer insight that we have gotten, which is with respect to choosing the name of the applicant entity. We've seen cannabis regulators in other states try to implement control over branding and whatnot, specifically with respect to slang terms about cannabis. But in Maryland, we're seeing that registration with the Secretary of State for an entity that is hoping to hold a license may not include the terms cannabis, marijuana, or other synonyms related to controlled substances. Now, that other synonyms piece is a little bit vague and, will likely be more subjective than objective. But the name can suggest the use of cannabis as an intoxicant, and of course can incorporate copyrighted material or trademark or service marks attributable to another entity. So, marijuana and cannabis should obviously not be in the name of an entity that will be holding a license. What's likely to be included in that is also, pot, weed, other well-known slang terms for cannabis. And then, of course, again, this will be a bit subjective and up to the decision of the regulators and Secretary of State. Next slide, please. So once you have your entity and you have your partners, again, it's very, very important to think about the access that you will have to capital. So figuring out how much will you need, where will it come from, how will you raise the money, and then, whether the partnerships that you form, how they will be feeding into the strategy of your business growth, as well as the regulatory qualifications that you're going to need. Some of the things to really keep in mind here, of course, are making sure that as you're raising capital, you are not running into ownership and control issues, and inadvertently or even purposely giving your financiers more control and more ownership than is permitted, especially if you're in a round one license. Next slide, please. Some things to consider when you are raising capital is, of course, whether you want to bring in an equity financier who will actually own a portion of your business, or you want to bring in a debt financier who, really depending on how your debt is built, and if it's not convertible debt, will, give you the money, you will pay them with interest. And once that's done, you kind of tend to part ways. Again, making sure that whether you are taking on a debt financier or an equity financier, they do not get more control than should be necessary. All veto rights continue to remain with the social equity applicant. All rights to enter into contractual relationships remain with the social equity applicant, or at least 65% thereof. And you're not running afoul of anything that would cancel the very license for which you are trying to get financing. Also important to think about ancillary documents that tend to come into play when you are taking on financing. So consulting, management services agreements, and things of that nature. Keeping in mind that those agreements may be subject to review by the regulatory authorities. So, you don't want to have disallowable revenues going to the management or consulting company, or disallowable amounts of control given to the management or consulting company. Next slide. One final thing to think about when raising capital is that investors may be limited in how many different licenses they can invest. So something to think about if you are an investor, figuring out where you want to put your investments, because again, you may not be able to go into every single license or every single applicant that you want to. And then again, as we've seen with just about every other state, regulators have pretty broad authority to ask for additional information. And this also leads to potential additional background checks. So something to keep in the back of your mind when you are working with investors and asking them what they are and are not comfortable with. And as an investor, thinking about what you do and what you don't want to have disclosed on an application.
Thanks, Sahar. So I saw a few kind of questions pop up in the chat about the municipal considerations here. So as I flagged before, the retail on-site consumption licenses, those lotteries will be conducted by county. Growers and processors lotteries will be conducted by region. And once you get conditional licensure, you're going to need to have a property and go through the local zoning approval process. Municipalities are permitted to, establish zoning requirements with respect to where these businesses can be located. There are frequently, friendlier or less friendly communities that may, kind of welcome the use or not welcome the use. So that's one thing to kind of consider as you move forward. Moving on to the next slide, please. So again, you want to kind of begin that due diligence, and that's something our office can assist with as well, particularly as we get more information on how these licenses will be kind of dispersed across the state. In addition to kind of this community outreach piece in terms of identifying where you'd like to locate your business, it's also important to identify, any key partners that may help you facilitate diversity initiatives in that community, and really thinking about how you can be a positive neighbor, a positive contributor to that community. While there aren't, any requirements for letters of support at this time or zoning approvals, which I think is a good thing in terms of kind of lowering the barrier to accessing the licensing round. I do think that it is important to still be mindful as to what that might look for on the other side of conditional licensure. Obviously knowing that, given the lottery award system, this is up to a bit of chance. So finally, putting all these pieces together in order to be entered into the lottery, you need to both draft and submit a compliant application. Again, this will include the operations plan, business plan, diversity plan, and verification of social equity status. Our office has helped many different entrepreneurs all over the country with this process. We're very excited to help people in Maryland get up and running in the manner in which the policy initiatives have been rolled out in Maryland. So if you're interested in applying, please don't hesitate to reach out. We're happy to be a resource moving forward. And with that, we can look at some of the questions here. So one of the first questions, when it says you can only apply for 2 applications, is it based on the individual or the entity? And references Connecticut as an example. My understanding is that it is intended to run up to the individual, like the example we provided earlier, that if it's, John Doe applies with ABC LLC, that John Doe can't join another applicant to try to stuff the ballot box, if you will. And I think that, that's intentional in terms of kind of leveling the playing field a bit. With respect to the release of zip codes, we are still waiting, but we do have, preliminary staffing at the Office of Social Equity. So I think that's a good indication that hopefully that information will be more available soon. I see a question here about the rolling 30-day deadline. That is just that there will be a 30-day submission period so that you could submit on, say it's a 30-day period between September 1st and September 30th. You could submit your application on September 1st. You could submit your application on September 30th or any day in between. We've seen more and more states doing this as opposed to kind of one final deadline. And I think it's, again, just kind of a way to make things more accessible over a period of time. There are not residency requirements for this round of applications. If you're an out-of-state resident, just like every other applicant, you will have to prove that you qualify as a social equity applicant. But say you lived in a DIA up until 2022, and now you live elsewhere, assuming you satisfy all their qualifications, you would be eligible for a license. With respect to the even distribution throughout the state, given this new information about awarding dispensaries by county and growers processors by region, it does appear as though there's a lot of intentionality around this to ensure that the new licenses won't be centralized or kind of clustered in one area of the state, so that there will really be broad access throughout Maryland. On the municipalities' question as to whether they'll be able to opt out, I don't believe that they will. I think that under the Cannabis Reform Act, they're allowed to set reasonable zoning restrictions, but they can't unduly burden licensees seeking to locate there. There may be some opt-out around on-site consumption licenses. And there is always at the municipal level, kind of the where the rubber meets the road in terms of zoning restrictions that may appear reasonable on paper and that may in fact be unreasonable based on the real estate market or other considerations. So I expect that all of this will begin to kind of come to light and become more of an issue on the conditional licensing side after January 1st of 2024. But again, something to be mindful of at this point, and to the extent that you're able to identify friendly communities, that's always a good thing. Sahar, did you have a question you wanted to look at?
Yeah, so as far as the question of bankruptcy goes and whether that's possible or not, of course, we've seen federal opinions come out with respect to bankruptcy not being available to cannabis. So of course, the bankruptcy exemption to the 5-year limitation on or the 5-year ban on being able to transfer is a little bit questionable as to how that will actually play out. As far as the entity having to be a Maryland entity, you can have other entities. Of course, it may be tax beneficial to have a Maryland entity, and it's the analysis of that will really be up to the individual applicant and their needs. Management services agreements in regards to limitation, that really depends on how the relationship is established within the management services agreement, whether it's more hands-on, whether it's more hands-off, whether we're seeing control or no control there. So it really is an individualized analysis of how much control and how much revenue is going to be cut into the agreement.
That takes us right about up to 2:30. We're happy to continue to discuss Maryland licensing. If you're interested, we can schedule complimentary consultations. Feel free to reach out either via email or in response to information that will be circulated with both the slides and the webinar at the conclusion of this event. And again, we're extremely appreciative of your willingness to take some time out of your day to join us today. We hope you found it informative. And we welcome any feedback, technology notwithstanding, on the content. And apologies again for that audio issue at the front. But hopefully everyone has learned something here and is as excited as we are about new opportunities in Maryland.
Thanks, everyone.
Thank you.